fundamental errors in law not having jurisdiction. I mean, because there's only a few things where you could actually lack jurisdiction. Venue, time limitations, wrong witnesses, and stuff like that. I mean, there's very few instances where the jurisdiction of the court can be challenged, and that's what we're doing. We're challenging the jurisdiction of the court to show them that they did not have jurisdiction over this crime at all, regardless of the first-degree murder. That's got nothing to do with it. You had to use another charge. You had to use another charge for your specific intent to bring a charge of first-degree murder. And that's all we want to do is put it before them and charge them with it. Charge them, and then I've got another little plan that goes along with it. Once it's filed in Leon County, then I'm going to have y'all file a complaint with the Justice Department in Washington, D.C.
Okay.
You see what I'm saying? And we'll bring them on board, because you've got a 38. You're going to at that time, or close to it, you're going to have a 37-year conviction. That was brought through malicious prosecution, and malicious prosecution is coverable under the U.S. Civil Rights Complaint 1983, because the law reads. I even got some case law in there for it. I got the Florida law in there. The law reads that they knew or they should have known that the charge was barred. They knew or they should have known it. They could have not done it for any other reason, but for whatever they did it for. We're going up under malicious prosecution, because that's what it is in Florida. It's under malicious prosecution.
Right.
We're going to put it forward. We're going to go with this, because I don't know. It just came to me. After Crump claimed, well, we can't handle it. We won't pick it up. This and that. Well, you know something? I've been running around here all these damn years thinking about how do I get a lawyer to bring a charge against another lawyer?
Right.
You know, and I just went over that. I just went over that thing and over that thing and over that thing and over that thing. And every avenue that I tried to take, I just kept coming up with dead ends. You know, so I sat about it, I thought about it. I said, well, God damn it. I said, if a crime is committed, a common citizen can bring a charge.
Right.
If a crime is committed against you, what do? And you do the same thing. You just go through the process. Except for y'all can do it because you're my family and you're my kids.
Right.
And you can bring it. You see, you can do that. And once it's done, then boy, look, it's on and popping. It's on and popping. But I couldn't do it, and they was ignoring me trying to do it. They wouldn't even answer. They wouldn't even answer my paperwork, you know.
And that's the Leon County Courthouse.
I know, but they can't do that against private citizens that are in prison. They can't do that against y'all.
Yeah, they can't do that against us.
They do that shit to inmates. They can't do it. They can't do it to y'all. They cannot do it. They got the answer. They got the answer. They got to put it in there. And that's going to be the starting point. And we're not going to let them drag on it either, because it's prima facie. Prima facie meaning it's evident from the record. It's right there in front of you. You ain't got to call the state attorney. You ain't got to call this person. You ain't got to do that. Here's our documents under the evidence code. I haven't got the evidence code in there. Here are the documents from the evidence code. All of these documents are evidence. They are official documents and acts. And everything can be ascertained from these documents. You ain't got to call in a police officer this and homicide investigator this, and you ain't got to call in another. You ain't got to do nothing. All you got to do is look at the documents and make a determination. It's simple as that. If your determination is wrong, we'll appeal it and go up top and get it filed on the list.
Right.
And that's where I'm at with this. 38 years later, it took a long time, but
38 years.
Well, it'll be 38 in January 17th. It'll be 38 years. Right now, we're just working on the 37. Long time, man.
And malicious prosecution. That's against the law all day.
I got the case law in it. It's a case law in it. It's called D. Benedictus versus Califano. And it's a case about a prosecutor in Florida in 1962 bringing a charge against his husband and wife, which he knew was barred on the face of the applicant, on the face of the pleadings, or he should have known. And of course, the local court went along with the prosecutor, but D. Benedictus appealed it, and it went to the First District Court of Appeal, which is in Tallahassee as well, and they sent it back down, and they said no, he could not have brought the charge for some ulterior motive. You know what I mean? Because it was evident from the dates in the indictment. That's the language. You'll see this in your package. From the dates in the indictment, he should have known that it was barred and that you couldn't bring it. You bringing the charge was done for some ulterior reason. You didn't like the people, or it was black, or you were overzealous, or whatever the case may be. But you brought it anyway, and you were outside of the jurisdiction. You had the people arrested, and the cause of action accrued when the person was arrested and put in the county jail and charged. Whether you dropped it, or whether it was void, or whatever the case may be, you still got the harassment, you got the intimidation, you got the embarrassment, you got all of that, even though they weren't in jail. They weren't in jail. They weren't in jail a day. But still, it's just the fact of the matter of what happened and how you did it.
Right.
What were your ulterior motives as a professional prosecutor, which you should have known. So that's the way the law reads, and that's what I'm going with. And nothing has changed legally about the statute of limitations in this country, except in Florida. 16 years after my conviction. Is he 96? Yeah, 96. In 96, they amended 775.15, which is the limitation statute. 775.15 now states that in the case of a felony in which someone is killed, there is no statute of limitations on the underlying felony. But they've done that, believe it or not. It's just not me, but they've done that just to close the door on something happening like that again. Because I've shepherdized and I've looked and I've looked and I've looked and I've looked, and I've never found a case like mine in Florida history.
Wow.
Never. Wow. I've never. This is a case, and even the District Court of Appeal said it in their opinion in my case. Even though we've never had a case like this, like Jackson's before. We go to New York and California, and this is what they do, and this and that. But that's just bullshit to keep from overturning my case. But they changed 775.15 in 96 to extend the limitation period on attempts or felonies in which the statute of limitations has expired, which is bullshit. I think it should be challenged, because you can't change the limitation period. The court can't.
Right.
So the Florida legislature has to go in and do it. The court can't do it.
Right.
The legislature has to go in and change it. And if the legislature changed it, federal law would override all of that and put it back just the way it's supposed to be. Because once the statute of limitations runs, that's it. Especially once you what's the word I'm looking for? Once you acquire it.
Yeah.
Or once you put it in and it's granted to you through the court, it becomes a bar, and it creates all other types of preclusive measures that go along with a judgment. It's res judicata, collateral estoppel, and all types of other estoppels that go along with it, and statute of limitations. I mean, just once it gets to a point, it's just a bar. You can't use that. You don't do that. You can't go with that. That's dead. You know, it's dead. You got to find another avenue. You got to find another avenue for going along with your charge.
So
they make shit so.
So
Go ahead.
What was the name of the prosecutor again?
His name is Donald Maliciously, but I'm pretty sure he's dead. But I'm gonna put him in there anyway.
Okay, so who was the sheriff? Who was the sheriff at the time?
84. I mean, it doesn't matter. It doesn't. The sheriff doesn't matter. But I think it was Raymond Hamlin.
So
no, it wasn't Raymond Hamlin. It wasn't Raymond Hamlin. It doesn't matter about the sheriff or the homicide investigator or any of those, because it was a whole tribe of them motherfuckers after me. Homicide, narcotics, crimes against persons. Man, you wouldn't even believe all the motherfuckers was trying to catch me.
So who was your lawyer?
Philip Padovano.
Okay.
The ex-judge. It's all in there. I sent you a copy of what I sent Phil about 10 years ago. I sent you a copy of it, of what I sent him, and I asked him to step in because he's the one that created the original defense.
Right.
He was the one that wrote the thing that got the attempted armed robbery dismissed before trial. So he understood, but he didn't follow up on what he had going. Because actually, all he had to do, through hindsight, hindsight is 20/20.
Right.
All he had to do was to file. Once they denied his motion in pre-trial, because he made a motion to move to dismiss all of the charges based on the statute of limitations argument. Now, all he had to do once it was denied, was that all he had to do was file what is known as a writ of prohibition, which is a writ prohibiting the court from going any further because they didn't have jurisdiction to do so. Right. That's why the opinion came out. That's why the opinion came out so screwed up and messed up and everything, because they were trying to fix the law right there in the court with this 5-year-old murder, this cold case. And they didn't want to let it go. For one thing, it happened 2 blocks away from down there 2 or 3 blocks away from the Leon County Courthouse, and it was a cold case. You know, they just didn't. They weren't gonna let me walk. As simple as that. They just were not gonna let me walk, and they didn't. So they just pushed it right on through. And the conviction sucks. It's a stupid conviction. The conviction is a conviction. It's so stupid because the principles of preclusion automatically tell you right off the bat what you can't do.
Right.
Come on, I'm full. Thank you. Go ahead. What'd you say now?
I say right.
Yeah. I mean, the issues of preclusion were already there.
Yeah.
I mean, the issues of preclusion are already included into a statute of limitations claim, because the basics of a statute of limitations is that time passes on, witnesses die, judges change office, evidence is destroyed or lost or whatever the case may be. And this is the whole purpose of a statute of limitations. So a defendant does not have to defend himself against stale evidence.
Against old evidence.
Old evidence, stale evidence, stale. Yeah, that's what they call it.
In the law books, they call it stale.
Exactly.
Yeah.
And it's stale. Once it's stale, then that's it. You can't. I can't defend again. Well, where were you at on the night of March 26, 1981? Here we is 6 years later. What the fuck? You asked me some stupid ass.
Like you gonna remember exactly where you at.
You have 1 minute remaining.
We done burned up 30 minutes already.
Oh yeah,
you. My damn big mouth.
Nah. You've been talking about that paperwork, and I appreciate it because I got it.
See, I want to give you a clue because I've never talked to anybody. Well, Tony understands it. Your Uncle Tony.
Yeah.
He understands it because we talked about it 1,000 times. But Mama kind of understood it. Mama was there, and it was just a wallflower. She's just.
Yeah.
Stinky. But she's a smart girl. But she's just certain people are smart in certain things.
Yeah.
Other things, they just lost. But anyway, this thing's finna cut off.
Call me tomorrow. Call me tomorrow.
Okay. We on the case.
All right, I got you.
Okay.
All right, keep your head up. I'll talk to you tomorrow.
All right.
All right.
Love you, man.
Love you too.
All right. Bye.
Bye.